Hey guys, unless you've been living under a rock, you know that ex-President Trump was booked. His mugshot's out. He's facing charges in Georgia. This video is not about whether Trump did anything wrong or didn't do anything wrong, or to try and tell you anything about how to think about Trump. It's only about an issue of the law that I've seen that's been confusing to some people, and I want to show it to you. So if you're taking pro or anti-Trump energy from this video, I think you'd be bringing it yourself, because that's not the point of this. But let's look at what this law is. And that is relating to the issue that I'm talking about, is the defendants trying to get the case taken from state court in Georgia to federal court, and why they would do it. So what does it take to do that, and why would they do it? So if you look at 28 U.S. Code 1455, you'll see the procedure for removal that is applicable here. And it's different than removal in a civil case, where the case gets removed and there's a stay in the state court when that happens. And that's not how it works in criminal court. And that's not what I would have thought until I read this, because I don't do criminal defense in federal court. So let's take a look. The notice of removal is that a defendant or defendants desiring to remove a criminal prosecution from state court shall file in district court where the prosecution is pending. So that tells you where they need to do it. A notice of removal, and signed by pursuant to Rule 11, just means that you're subject to sanctions if it's frivolous. It should contain a short and plain statement of the grounds for removal and a copy of all the pleadings and stuff. So here's where the rubber hits the road. You got to file it within 30 days of arraignment. Anything you leave out of it, if you look at subparagraph 2, is deemed a waiver. So that's bad if you forget something, but it says the court, if it wants to and is good cause, could relieve you of that limit. But read paragraph 3, because this is where the confusion starts. The filing of the notice of removal by the defense in a criminal prosecution shall not prevent the state court in which such prosecution is pending from proceeding further, except to a judgment of conviction. So in other words, the state process does not stop on this filing of removal, which Mark Meadows has filed that. I don't know if any other defendant has, and they may be trying to ride his coattails into it, which could be appropriate too. Whatever. The state prosecution is not stayed. Now, they did ask the court to do that, but I think the court came back and said, look, under the law, I'm not supposed to stay it until we have an evidentiary hearing. So I can't stop the state court from moving forward with their prosecution at this point. So then the United States District Court should file or examine the notice promptly. If it appears clearly on the face of it that it shouldn't be permitted, the court will make an order for summary remand. And they did not do that in this case. So I think they're going to evidentiary hearing. So in other words, on the face of it, the court sees the claim as potentially viable, which is good if you're a defendant. Now, I've seen some people saying, oh, the judge is rigged because he didn't stop the prosecution from proceeding. But look at the statute. It clearly says that doesn't happen. But what it does say is that the court doesn't send it right back down to state court. It shall order an evidentiary hearing to be held promptly. And I think Joe on the channel a little bit ago, talking on Eric's channel, Laid Back News, that he said the evidentiary hearing is going to be Monday. I haven't checked that myself, but I trust him on that. So on Monday, the court then would decide or take the evidence that it wants to hear to decide whether this case gets removed or not. Now look what it says. If the United States District Court determines that removal shall be permitted, it shall notify the state court, and the state court will proceed no further. So if this hearing occurs on Monday and the court decides, okay, this case belongs up in federal court, then the state court proceedings would be stayed. And this all comes out of the idea of a supremacy of the federal government. They set a rule up, which kind of makes some sense, which is we can't let any state actor anywhere around the country start arresting federal agents or officers or employees, which could stop the whole function of the federal government. So it's the federal government is considered supreme over the state governments for purposes of this law. And so if you want to do this, these defendants have the ability potentially to get the case taken to federal court where it would be dealt with. Now, what is going to happen to it? Let's look at another screen I've got here. All right, so we're now looking at Georgia versus Hines, which is in 2022, a decision issued. And look who is on the state side there, Fannie Willis. So this is the same prosecutor that is in the Trump case dealing with the exact situation I'm talking about, removal to federal court. And this matter is on before the court for the state of Georgia's motions to remand to state court or for an evidentiary hearing. So here the state's trying to get this stuff kicked back down to state court. And all the argument over that. So this is to do, I think, with somebody in the Marshal Service that Willis has taken a shine to trying to use her local office because she's an activist. That's what happens when you get an activist as a DA to prosecute federal officials here and there on very broad theories. So look what the court says. This is federal court. So this is really instructive to what might happen in this Trump case. A criminal prosecution against a federal officer or any person acting under the direction of a federal officer brought in state court can be removed to federal court. We just looked at that. Federal courts have allowed federal officers to remove criminal prosecutions commenced against them for the last 2 centuries. And we see in a statute that is now codified a very clear procedure for that. So the court says that the removal statute is an incident of federal supremacy. One of its purposes was to provide a federal forum for cases where federal officials must raise defenses arising from their official duties. Now I know what you're going to say if you're anti-Trump, which is he wasn't in his official duty. All right, right. I mean, that's part of the test. And if you're for Trump, you're going, well, he's the president. He has an interest in election integrity. Those are the arguments, okay? But what we'll look at is the actual standard that the court would use to make the decision here. The court says to successfully remove a criminal prosecution under the federal officer removal statute, a defendant must show that 1, he was an officer or any person acting under that officer of the United States. And some of these defendants certainly were that. So there will be a prong 1 satisfaction. He's facing criminal charges for or relating to any act under color of such office. Now, the state's going to debate that. They're going to say what they were doing was outside the scope of any authority that they had for anything they were doing on behalf of the federal government. Now, obviously, the defendants are going to say that watching the election and contesting anything that was potentially compromising to its integrity is somewhat, at least somewhat, within the scope of what we're supposed to do as federal officers. And that's going to be the argument. And then from that the defendant has raised or will raise a colorable federal defense. And that kind of relates to prong 2 because there is federal immunity if you're doing something within the scope of what your duties are as a federal agent. So kind of if you meet prong 2, I think you're probably going to be meeting prong 3. So the battleground will be that, though, whether they were in any colorable way within the scope of authority they had as federal officers. So the court notes that the statute was amended in 2011, and the court says, now a federal officer can remove a criminal proceeding commenced in a state court where the criminal charges involve actions taken in an official or individual capacity for or relating to any act under color of such office or on account of any right, title, or authority claimed under any act of Congress for the apprehension or punishment of criminals. So that's a pretty broad statute. They say circuit courts are split on whether the amendment broadened the scope of acts that allows federal officers to remove a case to district court, but the 11th Circuit interprets the phrase relating to broadly, requiring only a causal connection or association between the act in question and a federal office, a standard that is, quote unquote, quite low. So the way this would work is what the defendants are hoping to achieve is that the court will find in its evidentiary hearing that the case belongs up in federal court, that they've met these prongs, that they were within the scope of being federal officers, that their acts were within the colorable parameters of whatever that means, and that they have a potential federal defense, which if they met prong 2, they would, which is federal immunity. So what they want the case out of state court. They want all of that stayed. And then once they succeed there, they're going to ask the court to recognize their defense that the acts alleged were within the scope of what they were allowed to do as representatives of the federal government. It was within these parameters. And if they do, then the court should dismiss this case because they have federal immunity. And an example of that, a famous one that came out, was the sniper in the Ruby Ridge case who shot Mrs. Weaver, was prosecuted under state law, but that was moved up to federal court. And then the federal court found that this person, the sniper, was acting within the scope of the duties they had. There's nothing crazy about that. It was within the parameters of that. And so the state action was dismissed in that case. So that would be the strategy for the defendants here. Get it out of the local court because this is supposed to be a federal matter, and then have a federal judge test it whether this immunity defense applies or not. So there may be other things that happen in the case, but this is a significant one. And so now at least we know what the rules are to get it up there, and then what they're trying to do if they do get it up there. Now the court could do the evidentiary hearing and say, I don't think this belongs in federal court, send it back down to the state court, and then the state court would continue to proceed. But if the court thinks it should remain in federal court, then the state would have a stay issued, and they wouldn't be able to proceed against these people after that. That's it. Thanks. Bye.